This is case number IT 94-1A, the Prosecutor versus Dusko Tadic.
Mr. Tadić, can you hear me? Are we in communication now? Well, then, for the record, the registrar has called the case, and the appeals chamber recognizes the presence in court of Mr. Tadić, the appellant. I take it that appearances are as before, but perhaps there could be some utility in reconfirming that. So, Mr. Clegg, do I take it that you continue to appear for Mr. Tadić in all the appeals, Mr. Livingston, with you?
That is so.
Mr. Yapa, do I take it that you continue to appear for the prosecutor in all the appeals with you, Miss Hollis?
Yes, Your Honor.
Mr. Fenrick?
Mr. Fenrick. And
Mr. Keenan? And Miss Sutherland?
thank you.
The appeals chamber meets today pursuant to a scheduling order issued by the chamber on 2nd July 1999, appointing today as the day for delivery of judgment in this matter. So the appeals chamber of this International Tribunal will now deliver judgment. As will be explained, the judgment is limited to 2 of the 3 appeals now before the chamber. But first, there is a word of explanation. The appeals chamber is sitting in the absence of one of its members, Judge Nieto Navia. In exceptional circumstances, he cannot attend today's sitting. The President has made an order dated 2nd July 1999, of which notice has been given to the parties, authorizing the appeals chamber to deliver judgment in his absence. Copies of the judgment, which is in writing, will be made available by the registrar to the parties towards the end of this sitting. Following the practice of the tribunal, I shall not be reading out the text of the judgment except for the operative paragraph. Save for a reading of that paragraph, I shall limit myself to introductory matters. The appeals chamber has before it 3 appeals in this case. They arise in this way. The accused Dusko Tadic was indicted on 34 counts of crimes within the jurisdiction of the International Tribunal. At his initial appearance before the trial chamber on 26 April 1995, he pleaded not guilty to all counts. 3 of the counts were subsequently withdrawn at trial. Of the remaining 31 counts, the trial chamber found the accused guilty on 9 counts, guilty in part on 2 counts, and not guilty on 20 counts. Judgment was handed down on 7th May 1997. The related sentencing judgment was delivered on 14 July 1997. Both Mr. Tadić and the prosecutor now appeal against separate aspects of the judgment of the trial chamber. Additionally, the appellant appeals against the sentencing judgment. This explains why there are 3 appeals. A great deal of time was taken up by proceedings relating to requests by the appellant for leave to admit additional evidence. The main request, which concerned a proposal to produce more than 80 new witnesses, was made on 6 October 1997. It led to a number of steps and was determined on 15th October 1998. 2 further requests by the appellant for leave to admit additional evidence were made on 8 January and 19 April 1999, respectively. They were disposed of on 25 January and 19 April 1999, respectively. Oral argument on the 3 appeals was heard by the appeals chamber from 19 to 21 April 1999. On 21 April 1999, the appeals chamber reserved its judgment. 4 reasons to be given. Judgment on the sentencing appeal will be delivered at a later date. The present judgment relates to the appellant's appeal against judgment and the prosecutor's cross-appeal against judgment. As to these 2 appeals, I shall be doing 3 things. First, I shall introduce the text of the judgment of the appeals chamber. Second, I shall give a summary of the findings of the appeals chamber. Finally, I shall read out the disposition of the judgment of the appeals chamber. I make it clear that the judgment is set out in the text to be handed out. This statement is not the judgment of the appeals chamber, except for the reading of the disposition of the judgment. Perhaps I should say a word on the structure of the judgment. The judgment is divided into 8 sections. Section 1 sets out the procedural background of the appeals, together with the respective grounds of appeal and the reliefs sought. Sections 2 and 3 of the judgment discuss the appellant's first and third grounds of appeal, respectively. Leave to amend the appellant's notice of appeal to include a second ground of appeal concerning the conduct of former counsel was not granted by the appeals chamber and is not being addressed. Sections 4 to 8 deal with the prosecution's 5 grounds of appeal. So I shall now briefly go through the sections of the judgment. First, the appellant's appeal against judgment. There are 2 grounds. The first ground is as follows. The appellant's right to a fair trial was prejudiced as there was no equality of arms between the prosecution and the defense due to the prevailing circumstances in which the trial was conducted. As mentioned earlier, a second ground of appeal is not being proceeded with. The third ground of appeal is as follows. The trial chamber erred at paragraph 397 of the judgment when it decided that it was satisfied beyond reasonable doubt that the appellant was guilty of the murders of the 2 men concerned. As for the reliefs sought on behalf of the appellant, these are as follows. First, that the decision of the trial chamber that the appellant is guilty of the crimes proved against him be set aside. Second, that a retrial of the appellant be ordered. Third, in the alternative to the relief sought under 1 and 2 above, that the decision of the trial chamber at paragraph 397 of the judgment that the appellant is guilty of the murders of the 2 men concerned be reversed. Fourth, that the sentence of the appellant be reviewed in the light of the relief sought under 3 above. I now pass to the prosecutor's cross-appeal against judgment. There are 5 grounds of appeal, and they are as follows. 1. The majority of the trial chamber erred when it decided that the victims of the acts ascribed to the accused in section 3 of the judgment, that is the judgment of the trial chamber, did not enjoy the protection of the grave breaches regime of the Geneva Conventions of 12 August 1949, as recognized by Article 2 of the Statute of the International Tribunal. 2. The trial chamber erred when it decided that it could not, on the evidence before it, be satisfied beyond reasonable doubt that the accused had played any part in the killing of any of the 5 men from the village of ICTY, as alleged in counts 29, 30, and 31 of the indictment. 3. The trial chamber erred when it held that in order to be found guilty of a crime against humanity, the prosecution must prove beyond reasonable doubt that the accused not only formed the intent to commit the underlying offense, but also knew the context of a widespread or systematic attack on the civilian population, and that the act was not taken for purely personal reasons unrelated to the armed conflict. 4. The trial chamber erred when it held that discriminatory intent is an element of all crimes against humanity under Article 5 of the Statute of the International Tribunal. 5. The majority of the trial chamber erred in the decision of 27 November 1996 in which it denied a prosecution motion for production of defense witness statements. On the basis of grounds 1, 2, and 3 of its cross-appeal, the prosecution sought to have the judgment of the trial chamber correspondingly reversed. No reliefs were sought on grounds 4 and 5, but both parties agreed that these grounds raised issues of sufficient importance to justify a pronouncement one way or another. I shall now mention briefly the holdings of the appeals chamber. I shall deal first with the appellant's appeal against judgment. As to the first ground, the appeals chamber holds against the appellant's contention that his right to fair trial was prejudiced. As to the second ground, as already mentioned, this is not being proceeded with. As to the third ground, the appeals chamber holds that the trial chamber did not err when it decided that it was satisfied beyond reasonable doubt that the appellant was guilty of the murders of the two men concerned. So I come now to the prosecutor's cross-appeal. As to the first ground, the appeals chamber holds that there was an international armed conflict and that in consequence the grave breaches regime of the Geneva Conventions applied. The appeals chamber also finds that victims were protected persons under the Geneva Convention relative to the protection of civilian persons in time of war. The accused is therefore found guilty on the counts on which he was acquitted by the trial chamber on the sole basis of its findings to the contrary. As to the second ground, the appeals chamber holds that the trial chamber erred when it decided that it could not, on the evidence before it, be satisfied beyond reasonable doubt that the accused had played any part in the killing of the 5 men from the village of ICTY. In the view of the appeals chamber, the trial chamber also erred on the doctrine of common purpose. As to the third ground, the appeals chamber holds that an act carried out for purely personal motives can constitute a crime against humanity. As to the fourth ground, the appeals chamber holds that discriminatory intent is not required for all crimes against humanity, but only for such crimes relating to persecution. As to the fifth ground, the appeals chamber holds that a trial chamber may order, depending on the circumstances of the case before it, the disclosure of a defense witness statement after examination in chief of the witness. I come now to the appellant's appeal against sentencing judgment. As the judgment of the appeals chamber explains, sentencing in relation to certain counts on which the appellant was acquitted at the trial, but in respect of which he is now found guilty, will be deferred to a separate sentencing phase. That being so, the appellant's appeal against sentencing judgment will be determined when a decision is made as to sentencing on those counts. I shall now read the operative paragraph of the judgment of the appeals chamber. It reads thus: For the foregoing reasons, The Appeals Chamber unanimously 1. Denies the first ground of the appellant's appeal against judgment. 2. Denies the third ground of the appellant's appeal against judgment. 3. Reserves judgment on the appellant's appeal against sentence until such time as the further sentencing proceedings referred to in subparagraph 6 below have been completed. 4. Allows the first ground of the prosecution's cross-appeal, reverses the trial chamber's verdict in this part, and finds the appellant guilty on counts 8, 9, 12, 15, 21, and 32 of the indictment. 5. Allows the second ground of the prosecution's cross-appeal, reverses the trial chamber's verdict in this part, and finds the appellant guilty on counts 29, 30, and 31 of the indictment. 6. Defers sentencing on the counts mentioned in subparagraphs 4 and 5 above to a further stage of sentencing proceedings. 7. Holds that an act carried out for the purely personal motives of the perpetrator can constitute a crime against humanity within the meaning of Article 5 of the Tribunal's statute relating to such crimes. 8. Finds that the trial chamber erred in finding that all crimes against humanity require discriminatory intent, and holds that such intent is an indispensable legal ingredient of the offense only with regard to those crimes for which it is expressly required, that is, for the types of persecution crimes mentioned in Article 5, paragraph H of the Tribunal's statute. 9. Holds that the trial chamber may order, depending on the circumstances of the case at hand, the disclosure of defense witness statements after examination in chief of the witnesses, done in both English and French, the English text being authoritative. There then follow the signatures of the 5 members of the bench, dated this 15th day of July 1999, at The Hague, the Netherlands. Judge Nieto Navia appends a declaration to this judgment. Judge Haberdine appends a separate opinion to this judgment. There ends the final part of the judgment, and the registrar will now deliver copies of the text to the parties concerned. It remains to add that the Appeals Chamber fixes 30 August 1999 at 2:30 p.m. to hear oral arguments on sentencing for the counts mentioned in subparagraphs 4 and 5 of the disposition. Each party will have liberty to file a written brief in respect of that matter by 25 August 1999. The briefs may address the issue as to the relative seriousness in law of the crimes referred to in those counts from the point of view of penalty. As mentioned earlier, the appeal against sentencing judgment will be determined when a decision is made as to sentencing on the counts mentioned in subparagraphs 4 and 5 of the disposition. To return to the proceedings thus far, the result of the appeals chamber's decision, stated in a formula traditional to some law areas and perhaps more generally understood, is this: the appellant's appeal against judgment is dismissed. The prosecutor's cross-appeal against judgment is allowed. Will there be any applications from either side at this stage?
There's no application on behalf of the appellant.
For the Crown, for the prosecution?
We have no application.
Then there being no other business, the appeals chamber stands adjourned.
All right. Kan jij even